The USA Patriot Act was passed in a great hurry, as we all know, after 9/11. There was very little discussion, very little oversight. It simply was passed. This frightened the LWVUS, you might say. At least we swung into action very quickly. The League, for 84 years, has been especially vigilant, not me all those years, on the issue of civil rights. This has been an ongoing concern with our nation of how we protect our national security without sacrificing its citizens' civil rights. The LWVUS has a position, and I think I will read you some of it. This was presented by Kay Maxwell, our president, and I think it sets why we are here today and why the League is so concerned. The League of Women Voters strongly believes that civil liberties must be preserved and protected as the nation seeks to guard against terrorism and other threats to national security. We are particularly concerned about the impact of provisions of the Patriot Act passed by Congress in October 2001. The League supports congressional efforts to modify the extreme provisions of the Patriot Act, and we are concerned about new efforts to further expand governmental powers that infringe on civil liberties. Members of the League are steadfast in their conviction that the need to protect against security threats to America must be balanced with the need to preserve the very liberties that are the foundation of this country. There are fundamental principles that guard our liberty that must be preserved. Among them, independent judicial review of law enforcement actions and prohibition on indiscriminate searches. Now, with these things in mind, the LWVUS convention in June voted unanimously to make the Patriot Act an issue of concern for all the leagues across the nation. This was 700 League men and women voting for this. All of you who have been in League would be absolutely astonished that a group of that size actually came together to vote unanimously. That's how concerned we are. So with this in mind, we have invited Teresa Younger and Kevin O'Connor. Teresa is the Executive Director of the Connecticut Civil Liberties Union and has been their Executive Director for approximately 3 years and is an absolute pro at this, having spoken at over 200 different events, I believe. Kevin, when he arrives, is the U.S. and we had hoped to begin with him first because we felt we needed to say what is, and then Teresa was going to continue for there. But since he's detained in traffic, we'll ask Teresa to go ahead and get us started on this important topic. After Teresa has given her presentation and hopefully Kevin, then we will open the floor for questions. Thank you.
Thank you. Well, I will take advantage of the fact that Kevin is late today and I get the podium first. First off, I'd like to thank you all for coming out. This is a nice, easy ride for me since I live up in Shelton, and so when I had the option of coming south for this morning, I thought no problem. However, when I woke up and saw the ground was white, I was not necessarily so excited to get out of bed this morning, and so I'm sure many of you face that, and I appreciate you coming out this morning. Let me give you just 2 quick points about myself before I talk a little bit about this piece of legislation, and I will maybe speak until Kevin gets here, but I will kind of give you some history also. I'm an Air Force brat. I grew up in North Dakota, where my father spent 20 years in the Air Force. He traveled all over the country and finally settled in North Dakota well over 20 years ago now. I went to school at the University of North Dakota where I got a degree, and then moved out here and spent 10 years in youth development, which was my passion, was to change the world from young people up. And when the opportunity opened up for me to apply for the ACLU of Connecticut position, the CCLU position, I applied so that I could do reproductive, criminal justice, and juvenile justice work. And that was in July of 2001. So you can well imagine that my world turned upside down after 9/11, and it was like going through a master's degree program in civil liberties. because I didn't have a background in it, and I'm not an attorney. And I'm very fortunate because I get to work with attorneys, but it's not something that I have a legal background. So when Kevin and I debate this issue, you know, he can get into all the legal details of it, and I'll tell you all of the general perspective issues that we have concerns with at the ACLU. The legislation we're talking about. Sorry. All right, is that better? Yes. Okay, sorry. The piece of legislation we're talking about today is called the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. It only took about a week for me to get the title down, but the idea is this, you know, the fact that we call it the USA Patriot Act as its passage was to imply that if you didn't support this piece of legislation, you were quote-unquote unpatriotic. And language was coming out of the White House at the time from Ari Fleischer, who used to be the press secretary, who said, you know, watch what you say to the media. A year after its passage, you had Attorney General John Ashcroft say things like, those who scare peace-loving people with phantoms of lost liberty, my message is this, your tactic only aid terrorists and give ammunition to America's enemies. So this is the kind of atmosphere, and if anybody, I'm sure all of you recall where you were on September 11th, I truly can too, you know the emotional state that we were in. This piece of legislation, well, it passed overwhelmingly, that is true, was not necessarily passed with the discussion and the debate, and the process broke down. And I think that's the first problem with this piece of legislation. We rely on legislation to be brought forth, discussed, debated, and then taken to the next level, brought to the House and the floor, discussed, debated. A compromise bill goes to conference committee, and then a bill goes to the president and gets signed. And that is usually what has happened. In this case, that is not what happened. The House and the Senate had two different versions of a bill. One was called Uniting and Strengthening America. The other was called Appropriate Tools Required to Intercept and Obstruct Terrorism. Those pieces of legislation were put together for a 342-page piece of legislation, of which we know in the state of Connecticut, our representatives and senators did not have the opportunity to fully read. And we know this because when we ask them about it, they say things like, I believed in the concept of the bill. But what we also know is that prior to October 25th of 2001, there had been compromise language of a bill that really answered the concerns that are addressed in this piece of legislation, really put in the checks and balances that are needed. And that bill did not make it to the floor of either the House or the Senate. In fact, at 4 o'clock in the morning, a piece of legislation that merged both of those bills got rushed to the House and the floor. There was no real discussion or debate about it. And when there was a discussion in the Senate about whether they should vote on it, there was only one senator that voted against it, and that was Senator Russ Feingold. And he voted against this legislation, not because he thought it was a bad bill, but because he had asked his fellow senators for more time to read the bill and to give 24 more hours of open debate. And when they said no, he voted against the bill. And the other 49 voted for it. So that's a very quick outline of what was happening with the bill. And it should just also be noted, it is not just the ACLU that has concerns with the provisions of this bill. There are numerous organizations. In fact, conservative Republican Representative Don Young out of Alaska. Hey, Kev. I'm doing your part.
I'm just going to get up and say all lies. Even though
Don Young said, I believe it was stupid. It was called emotional voting because we didn't think it through and we didn't study it with regards to this piece of legislation. I will quickly touch on the parts of the legislation that are problematic, and then I will hopefully expand later on into Patriot Act 2, the 9/11 Commission report, etc. But since Kevin's here, he's going to counteract every single thing that I say. I can tell you what he's going to say, so I'll just start out now. First off, you should know that 90% of the bill is somewhat problematic, but not necessarily overwhelmingly a problem. And in fact, most of the provisions in the bill are not new. They are existing pieces of legislation that apply to other parts of criminal acts. And in fact, that this piece of legislation does not only apply to terrorism as it implies in its title, it also applies to routine criminal investigations. There are probably 5 to 10 provisions that are most problematic, and I will quickly, briefly touch on them and then let you know what's happening. These are not the only pieces, but these are the most offensive that people have found. And one most of you have heard about is called Section 215, having to do with tangible things. It's often referred to as the library records component. It's the idea that the government would have access to your First Amendment activities. And what most people don't fully understand is when we talk about Section 215, we're not just talking about library records. We're thus talking about your financial records, your medical records, your educational records, etc., your internet service provider, things along those lines. And how the government has access to those is one thing. As Attorney General John Ashcroft came out and said that librarians were being hysteric in reference to their concern about the government gaining access to what people were reading without having to meet the previous standard. And when they went further on with the idea that they were being hysteric, they said, well, it's really much broader than that, because not only under Section 215 does the government have access to those things, but the individual who is asked for information about them is then placed under a gag order. In addition to that, there's another section that's kind of contained under that having to do with national security letters. And national security letters were self-imposed subpoenas that the government gave to itself and then walked in and gave the information. There was no court overview. And this, again, had a gag provision to it, which caused many people's concern, because in that part of it, the national security letters, there was no judicial overview. Under Section 215, there is a judicial overview. Many would argue, as we have, that that overview is not adequate. The other component of the piece of legislation, sorry about that, this microphone keeps kind of dropping down. The other part of this piece of legislation that has been deemed problematic is called Section 213, and Kevin and I oftentimes, I'm sorry, Section 213, which we call sneak and peek searches, and Kevin calls delayed notification, and in all actuality, they're the same thing. We call them sneak and peek searches because the government has access to your home, your place of work, your place of business, etc. They can go in without telling you and search your home and retrieve stuff and walk away and never tell you about it. And I would say they don't have to tell you about it. Kevin would say, well, they have to tell you about it. They can just determine when that will be. And that most courts don't allow that to happen for more than 7 days. But we do know that people have reported their homes. A burglar has broken into their home thinking that it's been a burglar, and in reality, as investigations have progressed, we have learned that potentially it could be sneak and peek, that the government may have entered their homes and obtained records. The problem with this kind of search is that if you don't ever see the subpoena or the search warrant that the government is using to get into your home, you can't validate that they are in the right location, nor can you validate what they have opportunity to search, nor can you challenge them at the end of the day to make sure they haven't overstepped their bounds. And let's not be so naive to think that the government doesn't overstep its bounds, because it historically has. And that is why you have organizations like the ACLU to continue to question where those boundaries lie. Also under Section 213, this is the first provision that once the House and Senate realized that it could be used against them because it's such a broad piece of legislation, they actually voted to not fund it adequately. See, it seems really nice and dandy if you're going to identify that group over there and go after those people, but what if that all changes and that can be used against you? The language under the sneak and peek provision was broad enough that they were fearful that it could be used against political activity. And once they realized that, they stepped back and defunded it. It doesn't mean that it's not still a provision that can be used. It is a provision that can be used. Another part of this piece of legislation that has caused concern for organizations like the ACLU is the definition of domestic terrorism. It's a very broad definition that we have many concerns about. And I'll just give you a quick briefing on the definition. The definition says acts that are dangerous to human life, that violate any state or federal law, that appear to be intended to intimidate the civilian population or influence a policy of government. And if you meet this very broad definition, well, there are parts A, B, and C to it. I've read it in a very mundane language. The government can actually make a determination to put your organization out of business. And this definition even goes so far as to affect groups we traditionally would not have considered, quote-unquote, domestic terrorist organizations. Things like the VA case protesters, a group that strategically went down to the island of VA case. They strategically cut a hole in the fence, walked through the fence, otherwise known as trespassing. They put themselves and the individuals on the military base in harm's way. And many would debate when an Air Force base or a military base goes to high alert, that puts everybody's life on a heightened level. And in doing so, they had intended to influence government policy. There's no doubt about that. And the concern is really that this broad definition could be used against civil disobedience. And yet it hasn't been tested, we don't know, but it is very problematic. Another part of this piece of legislation that has been considered very problematic has to do with roving wiretaps. And I'll ask, how many of you have cell phones? You do, you don't have to raise your hand to do, but most of us have Blackberries, and we used to remember there was a time when you only had one phone, right? You shared it with somebody else sometimes it was just your landline. There were also opportunities where it was a phone number and you had a work phone number. These days, people have 3 or 4 or 5 ways of communicating with people. Your cell phone, your home phone, your work phone, your Blackberry, your this, your that, your other. And so, wisely in some ways, the government made a determination that they wanted to apply roving wiretaps more broadly. And what roving wiretaps do, as opposed to assigning a phone number, they actually attach a wiretap to an individual. So it is whatever forms of communications that I might myself use that would be tapped at the time. And they say, oftentimes, once you start talking about things that don't apply to what we are seeking the wiretap for, we will stop the taping. Mm-hmm. However, they actually expanded the track and trace device and roving wiretap information to include, expanded it to modern technology, i.e. computers. However, it is very difficult to read in a subject line what is happening in the rest of the email. And the idea that the government would stop reading the first line of your email, honey, we're going to have chicken for dinner, it's really an insane process because we know that much more goes through it, and that means the government has access to what we are communicating in a much broader kind of way. I will just say this, and there were changes to immigration laws and the government's ability to detain people, and I think the discussion is broader than just this piece of legislation. And Kevin can only debate this piece of legislation. It was rules and responsibilities that he gets to use and is empowered to use. I'd like to expand the conversation one step further, because I do think it's broader than just this piece of legislation. There is an atmosphere of fear and a chill in the air. And when that happens, we start curtailing individual civil liberties. I will just end briefly with one quick comment, which is the courts ruled that the use of national... Let me start out real quickly. John Ashcroft came out and said that he had never used Section 215 to get library records. It was this briefly after the ACLU had filed a lawsuit in Michigan to challenge Section 215. But we know from the Inspector General's report, the government's own report about itself, that libraries have been contacted over 80 times. And then we found out further that they were using this quote-unquote national security letter. And the courts just recently ruled within the past month that the use of national security letters is unconstitutional because there is no government oversight, and it does have the potential to infringe on the Fourth Amendment search and seizure and First Amendment association and free speech rights. And so the courts are moving into this battle, and they are moving in aggressively. But it will take time. And the other thing we need to remember is that rarely has a piece of legislation passed, and 3 years after its passage, it is still a topic of debate and discussion. That doesn't happen to the point where you're still talking about it even more 3 years after its passage than you did when it passed. People can hear the conversation now, we can ask the questions now in a very different way than we could before, and I think that is a very, very healthy thing. The other thing that I would just say is that if we don't ask the questions, if we don't hold government accountable, then we have broken down the true meaning of what a democracy is about. The one thing we need to note is that there is a sunset provision in this piece of legislation, which means some, not all, some of the components or provisions will go away effective December 31st of 2005. Immediately, almost immediately after its passage, the administration started calling on Congress to take away the sunset provision and to leave all of the laws as laws for the long term. He continues daily to call on that. And in fact, in every debate and discussion that took place, he continues to call on to take out the sunset provision. There is also some conversation and concern and question about the idea of Patriot Act 2 that is sitting out there in the 9/11 Commission report. And I think that we need to understand that there were some compromises made when the Patriot Act passed. However, it is the administrative branch of government that is ignoring what those compromises were. And they continue to call on the Patriot Act to be expanded, to be extended, and for more powers to be given when there has been no proof to this point that all of the powers that were requested in the Patriot Act have been used, nor that they have been effective. And the idea that the government would say to us, trust us, there's been no other terrorist attack, that you're safer with this piece of legislation, is an assumption that I don't think that we need to blindly close our eyes to. And it is our First Amendment right to question, and I would hope that we continue to do that. So I will let Kevin counteract every single thing that I said, and then open the ground for questions afterwards. Thank you.
Thank you, Teresa, and welcome, Kevin. We appreciate your coming so far, and on the Saturday, I know you're a family man, but we appreciate your coming. So with that, Kevin O'Connor, U.S. Attorney for the District of Connecticut, and you've got a hard act to follow.
Good morning, and again, I apologize for being late. A little bit of traffic, a little bit of family responsibilities, but as you can see, I have 3 young children, all under the age of 3, so coming out on a Saturday isn't a bad alternative to staying at home. I learned that as the days get shorter and the weather gets worse and you're stuck in the house with 3 kids, you pretty much look forward to anything. But I want to thank Teresa. Teresa and I, we have this sort of traveling road show that we've been doing this now for at least 2 or 3 years, going around the state. And sometimes people say to me, gee, doesn't that bother you that you have to spend this time, weekends and the like, defending it? And I suppose I don't have to. I'm not getting paid by the hour. But I do it not because I certainly agree with Teresa or the critics of the Act, but I think this is what our democracy is about. And I think this type of debate and this type of discussion is what it's all about. I welcome the scrutiny, and I welcome the sunshine that whether it's ACLU or other groups or Congress. I mean, we operate in a business where we get oversight from Congress, we get oversight from the courts, and we get oversight from defense lawyers and groups like the ACLU. And I think that's important. I don't take umbrage at that. I welcome it. So I do enjoy the opportunity to come out here and give you what I view as our perspective, or my perspective as someone who's been entrusted with these powers. I don't seek to convince people. I think at heart what's involved here is whether or not you have trust in your government. And depending on your own personal beliefs and experiences, the answer is oftentimes yes or no. And frankly, that's a question that we don't need the Patriot Act to debate. You can go back to the enactment of Title III in 1968, where Congress gave prosecutors the power to tap phones, and these similar debates, how much liberty, how much security. And I think 9/11 was another significant event, obviously, in this country's history. The Patriot Act was the end result of that, and now we're having that same debate, how much liberty, how much security. In my view, there's a pendulum between the two. And you have to decide, you being the voters in Congress, how far that pendulum swings towards liberty and how far it swings towards security. I'll exercise whatever powers I've been entrusted with. I don't have the lawmaking authority. If Congress amends the Patriot Act and takes away the authorities, I'm still going to do my job to the best of my ability. But there are consequences, and I want to touch on a few. First of all, I think when you look at the Patriot Act, there's a tremendous amount of misperception on the Patriot Act and misunderstanding. First of all, the Patriot Act has nothing to do with the prisoners at Guantanamo Bay. They're not there under the Patriot Act, and sometimes even the most astute of columnists and observers lump the two issues together. That's an issue of a separate debate, and I know there's a lot of concern on that, but just for clarity purposes, that has nothing to do with the Patriot Act or powers thereunder. Second of all, looking at the Patriot Act, putting it in perspective, there is no doubt that Congress acted very, very quickly. But it's understandable. It was October of 2001. We just went through perhaps the worst terrorist attack in our country's history. Over 3,000 people died, including many Connecticut residents, probably some from this very town. And Congress was reacting quickly. What can we do to prevent this? And Congress knew at the time they weren't engaging in the typical deliberative process by which they enact legislation. That's why the sunset provision was implemented. Let's face it, 99% of the laws that Congress passes, that our own state legislature passed, don't have sunset provisions. So what happens to the Patriot Act, or most portions of it? At the end of 2005, it goes away unless Congress specifically votes again to approve it. That's a very unusual provision. And I think Congress put it in there simply because it knew it didn't have the time, it didn't want to spend the time. Remember, October 2001, we were waiting for the other shoe to drop. We were in the middle of the anthrax inhalation. We didn't know if 9/11 was one series of events or was going to be a series. And Congress said, we're going to act quickly, but you know what? We want to be able to have some hindsight and look back in a few years, which is unusual. That's why we're here today. I think we're debating this act not because the act itself is so significant. Certainly Congress passes a lot of other acts. It's because we all know it's going away unless Congress specifically affirms it. So my view is Congress put a sunset provision for this very purpose, so that groups would spend the time debating the merits of the act with the benefit of some experience. We now have 3 years of experience. What do we know about the Patriot Act? We know a lot about what it could do theoretically, but we also know about how it's been used to date. And not even its worst critics are pointing even at the Ashcroft Justice Department and saying they're violating people's rights. It's all about what could happen. Now, I'm not saying we shouldn't have theoretical debates. I think they're very important. But you can't lose sight of the fact that we don't have armies of lawyers and defendants crying that their rights have been violated under these provisions. We don't. And so I think in the context of whether you approve this act or don't approve this act, you have to at least consider how it's actually being applied. Because the question is, do you trust your government with these powers? And the answer may be no. I don't think any government should have these powers. But I think in that debate, you also have to look at the evidence. How have we used the past 3 years these powers? I think another important aspect of the Patriot Act is all the provisions you're talking about. Now, sneak and peek and delayed notification. Delayed notification is not Kevin O'Connor's characterization. That's Congress. That's what Congress calls it. Nowhere in the Patriot Act is the term sneak and peek found. That's what the critics call it. I refer to it the way Congress does. Delayed notification. The way the courts refer to it. Delayed notification. Unfortunately, the dialogue has made me use the term sneak and peek because people have been very effective in characterizing it that way, but that's not what it's called. It's called delayed notification. And it's a provision that courts have allowed us in Connecticut to use for 20 years prior to the Patriot Act. The Patriot Act simply codified a common law power that we had previously enjoyed. So when you ask me, has the Patriot Act changed my life, my abilities? In fact, it really hasn't in many ways. For two reasons. Number one, a lot of those provisions in there are things that are to be used very rarely. Number one. Number two, a lot of the powers, as Teresa acknowledged, we already had. And some people say, well, if you never use these powers, why do you need them? Good question. I bet you most of your Weston police officers never used their revolver in 25 years, 30 years on the service. Do we think they shouldn't carry them? The reality is we have these powers because there are circumstances where we may need them. And if we're not abusing them, then I don't think there's real great cause to take them away. Look, if we abuse your rights, and by the way, we're a government of people. There are bad cops, there are bad agents, and God forbid there are bad prosecutors. We don't need the Patriot Act to trample over your constitutional rights. Mistakes happen. Bad people get into government. It happens. It happened before the Patriot Act, and even if the Patriot Act goes away, there will be abuses afterwards. So what are the remedies? The courts. Section 215 has to be approved by the FISA court, the library provision. Delayed notification, I can't sit in my office in New Haven and say, hey, let's go look at Crew and Woody's library records. I've got to walk into a federal judge, appointed separately by the president for life, not in my branch of government. I have no authority over that woman or that man, and I have to convince that judge. And you don't think judges ask those type of questions? Wait a minute, a library? So please understand, this isn't a bunch of prosecutors who just decide to go. There's a very important oversight there in the courts. We have to go to courts and approve this. And I've done this process. And these affidavits to get search warrants and to be able to do this type of stuff are typically 100 pages long. And we've been doing it with wiretaps for years. As you know, let's talk, public corruption seems to be our biggest issue of the day. But in the Ganim prosecution, the Giordano prosecution were built on wiretaps, good old-fashioned wiretaps. And we've been using those for years. Now, every single one of those wiretaps was approved by a court before we were allowed to use it. And if you think there's anything political going on, as I say all the time, of the 10 active federal judges in Connecticut, 9 of them are Clinton appointees, and I'm a Bush appointee, so they don't rubber stamp. And even if they were Bush appointees, they wouldn't rubber stamp. The bottom line is we have to go through judicial approval, and that's the checks and balances that have always existed. The Patriot Act doesn't get rid of the courts, it doesn't get rid of the Fourth Amendment, it doesn't get rid of any of your constitutional rights to challenge what we have. Now, reasonable people can disagree, and I'll never convince people, if you really believe that under no circumstances government should have these invasive powers, I don't think that's an unreasonable point of view. I don't agree with it, but I don't think it's unreasonable. But I think what oftentimes gets lost in the debate, you see the editorial cartoons about FBI agents looking at somebody's library records over their shoulder. There's one with a little kid reading Dr. Seuss, and the FBI agent says, "Excuse me, I want to see what you're reading." It's funny, but the reality is when we disclose that not one public library in the United States has been searched under the Act, I think that tells you that we don't willy-nilly run into public libraries and search records. Now, public libraries have been a real heated debate, and I understand that. Everybody understands the privacy, but let's not be so naive to think that people don't use libraries to commit crimes. There are hundreds, if not thousands, of examples. And you know why they use them? For the very anonymity they hope to get. Child pedophiles. Well, rather than try to lure a child into a sexual compromising situation, they'll use a library computer where they can hopefully sign on anonymously rather than their home computer, because they figure they can't get caught. It happens. Number one. Number two, Ted Kaczynski. You remember the Unabomber? Ted Kaczynski pled guilty. One of the ways we were able to identify him is his brother obviously referred FBI agents to him, but that enough wasn't alone, because his brother didn't know he had committed these crimes. He just sort of said, "Hey, my brother's kind of a strange guy. He lives up in the woods in Montana. He's a bright guy. He's capable of doing this. I don't know if he is." Well, that's not enough to get Ted Kaczynski charged and for Ted Kaczynski to plead guilty. One of the key pieces of evidence came from a public library. If you remember the manifesto he published, that lengthy manifesto where he railed against modern society, he's a very bright guy. He cited some obscure treatises. Some FBI agent, I don't even know where this person was, said, "Geez, maybe we ought to look at where you get those books, because they're not very common books." It's not like he's citing the Encyclopedia Britannica. He's citing these very obscure treatises. So they did a search in a database and found out that 4 public libraries in the United States had one of the books cited. Well, they said, "Don't you think we want to go see who checked out those books?" Sure enough, at the University of Montana, Ted Kaczynski had checked out a book cited. And he was the only one in the last 15 years that had checked it out. That was a key piece of evidence in prosecuting him. And had we not had the ability, and by the way, that wasn't under the Patriot Act, that was a good old-fashioned grand jury subpoena, we never would have gotten that key piece of evidence. So I don't think it's a good situation where we should never be able to go to libraries, because I think criminals will take advantage of that. So the question is, when should we be able to go in? And under the Patriot Act, we can only go in if the FISA court approves us. But the reality is, a grand jury doesn't need court approval to subpoena library records if they have reason to believe a library or a patron of a library has used the library to commit a crime. They can do that every day. So even if you take away the Patriot Act, the grand jury still has the ability to subpoena library records. And they do it. And I hope you understand why there are circumstances, why we would do it. So I think sometimes lost in the debate here is the real life consequences and the real practicalities that go on every day when you make decisions about whether or not to use the Patriot Act or any other provision. Let me talk about the definition of terrorism, which has gotten a lot of criticism, particularly by the ACLU. I read something the other day that was very interesting. Apparently the ACLU rejected a $1 million grant from the Ford and Rockefeller foundations because the grant said you could not use the money to promote or engage in violence, terrorism, bigotry, or the destruction of any state. The ACLU said, we're not going to accept that money with those conditions. And when they asked the ACLU's leadership, and this is according to the New York Times, as to why you didn't want to do that, I mean, let's face it, bigotry, the ACLU for years has defended bigots, whether it's Skokie, Illinois, or the right to free speech, even of those whose speech we abhor. They said, no, that's not our concern that you don't let us use it for bigotry. It's the definition of terrorism. And ACLU Executive Director Anthony Amaro advised the Ford folks instead to adopt the definition of terrorism. Where? Brace yourself. found in the Patriot Act. So I find it, look, terrorism is defined in the Patriot Act as people who advocate material harm to you, violence. It's not political groups. It never has been used that way. Theoretically, I suppose you could do that, but there are procedures and mechanisms by which to challenge that, and nobody has claimed they've been unfairly characterized. So certainly we can talk about hypotheticals about how you could be defined as a terrorist, and I can't defend our nation's history where there have been instances where people's rights have been violated. But practical experience shows in the Patriot Act that that's not happening. And I think that that sometimes, again, is lost in the debate. The other issue, this act has been under constant attack in the courts. People bringing challenges, the ACO, that is their right. I support that. If you have any reason to believe any act out there is unconstitutional, that's what the courts are for. And this act has really withstood incredible attacks on its constitutionality, all different provisions. And as I said, that's great. That's what these acts are for. You're supposed to be able to litigate them in the courts. But the provision that Teresa referred to, the national security letters, is one of those provisions that existed prior to the Patriot Act. And in a press release, when the court in New York struck down that provision, it was hailed as a landmark victory against the Ashcroft Justice Department. The funny thing is, that provision existed previous to the Patriot Act, and guess who its sponsor was? The noted right-winger Senator Patrick Leahy, who said at the time that Section 2790 provides a clear procedure for access to telephone toll records and counterintelligence investigations. My point is simple. These provisions have been around for years, and I think it's perfectly valid to question them. But my question is, why now? Where was this debate 5 years ago? 10 years ago, I could use a delayed notification search, and nobody seemed to care. 10 years ago, I could use roving wiretaps, and nobody seemed to care. Now, all of a sudden, after 9/11, there's this tremendous uproar at the Ashcroft Justice Department for using these provisions. Yet nobody's claiming their rights have been violated under it. So the theoretical debate is a very important one. And if people don't believe we should have these powers, I respect that, and we should debate that. But sometimes I think it's gotten too personal, I think it's gotten too political, and I think it's gotten too emotional, this debate. And it's been focused on particular people. John Ashcroft didn't invent delayed notification searches. He didn't invent roving wiretaps. We were able to do that prior to the Patriot Act. And let me talk briefly about those provisions. Why would we want to do a delayed notification search, or as its critics refer to it, sneak and peek? Sounds pretty invasive, and it is, as is tapping your telephone. We have cases here in Connecticut, in Fairfield County, primarily drug cases. But the purpose of delayed notification is, again, I can only do it if a court approves it. I can't do it on my own. We had a case where we had a big drug dealer in Fairfield County who was selling drugs every week in your communities, taking the cash, and on Fridays he'd go to a UPS box and he'd send the UPS package to Texas. We had been observing him, surveilling him, all the conventional law enforcement techniques that we don't need court approval to follow you, watching him, and we concluded that he was using this UPS weekly shipment to send the proceeds of his drug dealing to Texas. So we went to a court and said we'd like permission to search the package when he puts it in there on Friday. But we want to reseal it because if it does in fact have drug money, we want to see who's picking it up on the other end. Because, yeah, we could arrest the guy here, but it'd be awfully nice to take out the organization in Texas too, so we can kill the whole drug organization. Court approved it. We went, we opened the package after he deposited it. Sure enough, it was a big catalog and he'd sewn $100 bills in all the pages, and that was the way he was going to transfer the drug proceeds. We confirmed that it was what we thought it was. We resealed it, let it get shipped to Houston. We had FBI agents wait there, wait till the person came, pick it up at the post office, followed them back. Sure enough, they went back to a big warehouse. We followed them into the warehouse, and what did we find? Crates and crates and crates of cocaine and heroin and all sorts of drugs. Now, what delayed notification let us do was not notify him the moment we searched his package. Let us seal it back up and wait 48 hours until we've taken down the other end transaction. Had we not been able to do that, what would have happened? If we had walked up and said, "Excuse me, sir, give me your package, here's my search warrant," and looked at it, first thing he would have done is sent a message to the folks in Houston that they got me. Or they never would have sent the package. We never would have found out who was doing it in Houston. So there are consequences. There are reasons why we use these provisions. Again, the length of the delay, that's for the court to decide. We'll make a recommendation and say we would like 48 hours, a week, 2 weeks. But only if the court decides that it's reasonable. I don't arbitrarily decide how long to delay notification. I'll make a case to the judge as to why a certain time period is helpful so we don't compromise the investigation. But if the court doesn't like it, the court's not going to approve it. And again, I think sometimes lost in the debate is the fact that courts have tremendous oversight over these provisions. And let me just finally talk about Section 215, again, the library provision. And I think I've touched on it for a fair amount of time, but essentially it's a provision that allows us to go in and find tangible records. Nowhere in the Patriot Act is the term library even used, so it's not directed at libraries. But libraries, and to their credit, it's certainly their right to do so, have particularly been upset about this provision, so it's been referred to as the library provision, but the reality is it applies to any business. Are any of you in the insurance business or brokerage industry? Well, if you know what our attorney generals do every single day without court approval, is they issue these blanket subpoenas. They say, I want every single email in that company, and they start fishing around and look for trouble. They can do that for your medical records. They can do that. They don't even need a court. Our state attorney general can issue subpoenas on his own for any record of any business. He does it all the time, and he does it effectively, by the way. So this power, sure, it's an invasive power, but it's not a power without precedent, and it's certainly not only the U.S. government and the Department of Justice that has these types of invasive powers. And when you figure we've never actually used it at a library, when our Attorney General can easily issue a subpoena, Dick Blumenthal can issue a subpoena to this library for all the records that somebody took out. It's perfectly appropriate. I don't think he has, nor have we, but he can. So there are a lot of provisions out there that other authorities have that are very similar to this one as well. And I think that, too, is sometimes lost in debate. And finally, the other provisions, and Teresa and I both agree, about 90% of the Act is really uncontroversial. People don't talk about it because 90% of what the Act does is technologically neutralize the law. What does that mean? Well, a lot of these provisions, when we were given wiretap authority, were adopted in the 60s when we had rotary phones. We didn't have two-way pagers, beepers, Blackberries, emails, and the like. Now we do. And so what the Patriot Act does is try to modernize the law so that we can do what we do on rotary phones to cell phones and all those other types of devices that now exist. Roving wiretaps is a good example. Let's face it, when we first authorized wiretaps, there was no such thing as cell phones or calling cards. Drug dealers are smart. They know we wiretap phones, so they use a different phone every day and throw it out. What a roving wiretap does is allow you to go to court, again, to a court, and say, Your Honor, this is a defendant who we've established uses a different cell phone every single day precisely to avoid us wiretapping his phones. We would like permission from Your Honor to tap the person. That person, not his phone, because he's using a different phone every day precisely to avoid surveillance. We want to have a wiretap on that person. That's what a roving wiretap indicates. Something we could do prior to the Patriot Act. The Patriot Act simply codifies that provision. And again, we don't use it every day because the courts won't let us use it every day. But we do use it because it's the only way in this day and age with advanced technology to be able to track these types of illegal activities. And as I said, you can say no government should have the authority to tap phones. I don't think that's an unreasonable position. I will tell you it will significantly compromise our ability to bring cases. We never would have been able to charge Phil Giordano. We never would have discovered what he was doing to those little girls had we not been able to tap the phones. So there are pluses and minuses of every position we take here, and there are real consequences. And what I try to do is provide real-life examples as to why these powers exist, how we're using them, and why I think they're important to law enforcement, pre-9/11 and certainly post-9/11. Here in Connecticut, we have not had, knock on wood, an occasion to do a major terrorism investigation because we have not been the victim of a terrorist attack. So I can't give you numerous examples, if any, where I've used the Patriot Act to go after a terrorist. But I will tell you something. And if God forbid we ever have an occasion where there's a terrorist attack, I'd like to have those tools in my belt. Because there may be a time when I need them. And that's what the Patriot Act exists for. That's why I believe it's an important act. Not just for terrorists, of course, but also for drug dealers, for corrupt politicians, and all the other criminals in this state that we have used these same provisions in the past. So whatever Congress decides, and I obviously don't have a say in that, I will obviously respect and I will work with whatever tools I'm given. But I think in this debate it's very important to know that there are consequences to a decision to significantly curtail the Patriot Act. You will be, in a sense, tying law enforcement's hands. That may be a price worth paying to many of you. And that may be a justification and the liberty interest that you're concerned with may outweigh that. But that is a real issue that we need to consider in this debate, and I think, unfortunately, it's sometimes overlooked. So I will end with that, and I look forward to, obviously, the most productive aspect of these panels, which are your questions. Thank you.
Thank you, Kevin. This portion of the program, we're going to ask you to speak into the mic because that's the only way the tape will pick it up. So we will open it now for questions. You may direct your question to either of the speakers. We will hope that you make it broad enough that either one can respond. But who wants to go first? Prue, you're on.
Thank you. If, Kevin, you said that people wanted to curtail the Patriot Act, well, if so much of the Patriot Act is already in effect from previous laws, what would curtailing the Patriot Act do?
Well, I mean, I guess there is some legislation out there, and there's two things the Patriot Act could do, the legislation could do. It could modify existing provisions, put additional safeguards in, which is, I see, one theory. My biggest fear is if they do not reenact the Patriot Act, we will lose roving wiretap, we will lose delayed notification, which will put us in a worse position than we were on September 11th, because back then, courts approved it. We were able to go to a district judge, and the courts had always approved it. If Congress comes and says you can't do that, I don't think a court can go back to the days where they approved it. So I think it would actually be a step back if they got rid of these provisions. What I hope, if they do anything, would be to modify these, and I think Teresa and others can talk to you about what they're proposing additional safeguards be added. But my biggest concern was, if you don't reenact the Patriot Act, we're not where we were at 9/11. We're actually worse off than we were at 9/11 because we've lost powers we had prior to that. That would be my concern.
I would just say a couple of things. One, the sunset provision does not apply to sneak and peek searches. It does not apply to the roving wiretap or trap and trace information. Those will stay in place. So, that's one concern. The other thing that I would say is it's good to have healthy skepticism of government. I think the all trusting is a little bit detrimental to us all. The last thing that I would say in addressing this issue is that the problem with the Patriot Act, and I didn't get into it, and Kevin kind of makes it sound like it's all okay, is we did rewrite some of the overview and judicial oversight of this piece of legislation. The idea of going to the foreign intelligence courts, which were set up in the 70s because government had overstepped its bounds and was monitoring and wiretapping American citizens, is that this is a secret court. Its information is not public. And there is a lower standard by which you go to that court. You don't have to meet the probable cause standard when you go to that court. You meet the reasonable standard. It's all done behind closed doors. You don't know what is being used. And only once in its history has this court come out and said, and they released it, that they were denying the wiretap provision or the sneak and peeks provision or whatever it happened to be. The other side of this that Kevin doesn't get into is that when you go to a criminal court, the language, the plain language of this piece of legislation expands it to say that all that the government has to prove is that this is needed as part of a quote-unquote ongoing investigation, and that the courts need to certify it. So it's a very different level of proof that you go into the courts with, and it gives a very different level of responsibility to a judge to debate it. So what we are asking for when we talk about modifying the USA Patriot Act is that there be adequate safeguards put in place. Some of the adequate safeguards that were not put in place was a proper reporting mechanism from the administrative branch of government reporting back to the judicial branch of government. In fact, when the legislative branch of government, the Judiciary Committee, asked the Department of Justice to tell them how the USA Patriot Act was being used, the first few requests were turned down, and the Department of Justice said to the legislative branch of government, you don't need to know, it's a matter of national security. And it took a court case brought by the ACLU to request the information on behalf of the legislative branch of government. So we have to understand that, in the haste to pass this legislation, we didn't put in the checks and balances, and we didn't put in the reporting mechanisms that need to be there. I wouldn't recommend that any of you go and read this legislation because it is very, very complex. And in fact, I attempted to read it, had no idea where I was going, but I made it through all 342 pages, and then went and read the analysis, both by the government, by the ACLU, by the NRA, by the Eagle Forum, by the Cato Institute, by a whole bunch of organizations that are sitting out there contemplating, debating, and have raised concerns about the privacy, the oversight, and the government infringement potential of this piece of legislation. And just because it hasn't been, we don't hear about the challenges, doesn't mean that the challenges are not going on. And that needs to be stated also.
This question is directed to Mr. O'Connor. I'm just curious as to whether or not you need the same standard to get a warrant, i.e. probable cause, when you go out for, when you seek it. And number two, are there limitations on the length of time that you can have the so-called roving warrant